Case number 112277, State of Kansas v. McBride.
Good morning. May it please the court. Carol Longenecker Schmidt, representing Mr. McBride. Mr. Chief Justice, I would like 3 minutes for rebuttal.
3 minutes is granted.
Thank you. By way of offering a brief procedural background, this is a criminal case that stems from Shawnee County. The state charged Mr. McBride with 1 count of rape, 1 count of aggravated kidnapping, and 2 counts of aggravated criminal sodomy based on an event that occurred with his on-again, off-again girlfriend. The jury convicted Mr. McBride just of aggravated kidnapping. Mr. McBride appealed, and on appeal he argued that the prosecutor made erroneous remarks during closing argument. The Court of Appeals found that there was 1 erroneous statement that the prosecutor made but refused to reverse, finding that error to be harmless. And Mr. McBride petitioned for review, and here we are today. So I think there are 3 ways that this court, or 3 paths that this court could take that all lead to the reversal of Mr. McBride's conviction for aggravated kidnapping. The first is to take the Court of Appeals opinion, which found that the prosecutor's statements that Ms. Craig deserved a presumption and deserved some consideration. The court found that that was error. The first is to take that and move on to the harmless error analysis. The state, I do not believe, cross-petitioned the Court of Appeals finding that those statements were error. So I think the understanding is those are error. Our argument would be, even if you just look at that 1 statement, that still results in reversibility. The second path would be to take the 1 erroneous statement and then the other statements that we allege are error, find additional errors, and reverse. And the third would be sort of what I'm going to argue is an in-between path. We have the 1 error that the Court of Appeals found, and then some other statements that this court could conclude come up to the line but don't quite cross the line. But the combined effect of these statements that are perhaps not all the way error but are on the line is to cast a tone of argument that is disparaging to Mr. McBride and bolsters the credibility of the victim, and that these statements, while they may not cross the line, push us over to requiring reversal.
Have we ever done that before?
I do not believe, Your Honor, that you have.
And the question, of course, would be if a statement's not error, then it's proper. And how can we rely on a proper statement to reverse a conviction?
I think that can be done because for 2 reasons. When I read this court's opinions evaluating prosecutorial misconduct, there's often a lot of language indicating that sometimes the line is not particularly clear. And often this court will say, well, this statement, we're going to say it's appropriate, but do not do it again, or this is not really the best. And so I think you can have statements, individual statements, that while individually they don't cross the line, collectively, if you read them all in context, it creates an overall tone or larger argument that is disparaging to...
Isn't that precisely what Sherman wanted to get away from? The using ill will, bad faith, that kind of thing in the reversibility step. You know, we said we don't even care if it's inadvertent. We're looking at impact on the jury, not on the culpability of the prosecutor. Sherman basically said, if we have some culpability on the part of the prosecutor, that's a matter for the disciplinary administrator to handle. It's not a matter of guilt or innocence or reversibility. And so I hear you saying that if we get close to the line on a bunch of the others, that makes the 1 error more prejudicial. And that's kind of what we did in the Tosh analysis, wasn't it?
I think what I'm arguing is consistent with Sherman, because I'm not necessarily arguing that this court should give weight to these statements because the prosecutor intended them to be erroneous, or I'm not talking about the prosecutor's intent or the prosecutor's mindset. I'm saying that the jury could hear some statements that are could go either way. And after a while, after you hear so many sarcastic statements that individually might just be a rhetorical flourish, I'm thinking about the perspective of the jury and the impact on the verdict, which I think is what Sherman says we should look at. Evidence is important, but most important is the impact of the error on the verdict. So that's the best answer that I have for Your Honor's question, which is I'm not trying to get at like the prosecutor's intent, but I think you can have some errors. I think you can have things that don't quite rise to the level of error that collectively can influence the jury. But alternatively, we do still maintain that these individual statements are error. And the most important, I think, argument we have is that the error that the Court of Appeals found, that does result in reversal. And that's because that was an error that focused on the credibility of the alleged victim. This was a case about credibility. The jury did acquit of some of the charges.
How do we weigh that? The Court of Appeals seemed to place a lot of emphasis on the fact that he was acquitted of the major crimes in the case, and then even the conviction for kidnapping was a lesser of aggravated kidnapping, and therefore the truthfulness of the victim's statements were taken into account by the jury, weighed and assessed, and clearly didn't believe everything, at least beyond a reasonable doubt, that she had to say. How much of a factor should we place in what the jury did here? And that was convict on one lesser count, albeit a significant crime, and resulted in a significant prison time here. But how should we look at that, and what the end result was, and what the jury did?
I think that
in light of the errors.
I think that it is a factor. Of course, my interpretation is a bit different than the Court of Appeals interpretation. You could reach the result that the Court of Appeals reached, which was that the verdict was a result of the jury believing partially the testimony of the state, but not all of it. You could conclude, as does happen sometimes, that this was a compromise verdict, that there were some jurors who believed the state's case and some that didn't believe it, and so this was the compromise. And if that's the case, if that's a possibility, then I don't think this court can conclude beyond a reasonable doubt that the statements about the victim's credibility didn't lead to the outcome. There's uncertainty. I mean, I interpret the verdict as casting uncertainty about what the jury was thinking. And in a credibility case, if there's uncertainty and there's a prosecutorial comment, an error that directly relates to credibility, it's hard to get over that harmless error standard.
I'm trying to focus on the Court of Appeals and the state's notion that there's significant or overwhelming evidence for this particular crime. And I want to tell you what I'm looking at, and I want you to tell me if I should look further or do something different. But I'm looking at the elements of the crime that he was convicted on. And I don't see on the element of accomplishing the taking or confining of the person, accomplishing that by force, threat, or deception, that element, I don't see any evidence at all at trial other than the victim's word and the defendant's word. Should I look further than that one element to do the same thing, or is that where the focus needs to be in this case? Are there other elements where it gets down to being that thin?
I think there was agreement that Craig and Mr. McBride traveled together, so that would be taking. I do not know the best way to answer Your Honor's question. I don't think that there...
Well, first of all, do you agree that on that element, we only have her testimony and his testimony?
Yes.
There's nothing else out there for that element?
I I agree. There were
So for any other elements, are we down to just those two? Or it seems like we've got a little bit else on everything else.
I think so. There was testimony showing that, like, Miss Craig was at the house on Miss McVicker Avenue. There was some other. The state provided other corroborating evidence, but I believe you are correct, Your Honor. For those elements, that would be the crucial point where credibility is most important in the jury's determination. And so, Your Honors, as I mentioned, there are several ways that this court could reach the conclusion that Mr. McBride's conviction should be reversed, and we respectfully request that this court do so.
Do you have any more questions? All right, thank you, counsel.
Good morning, may it please the court. The state appears by Assistant Solicitor General Jody Litfin. I will go ahead and begin with opposing counsel is correct that there was one error that the Court of Appeals found that to be harmless error in this case, and that the state did not cross petition. So we are stuck with that finding of error here.
Let's just look at that for a second. You wouldn't seriously contend, really, that a statement that this particular witness is entitled to a presumption of credibility, that's a correct statement of the law. I mean, this is error. I mean, regardless of whether you're stuck with it or not, you really don't want to make the other case, do you?
I would argue, well, I can't argue, but if I were given the opportunity to argue, I would say that it's not a correct statement of law, but that's not what the prosecutor was saying here. I would say that his comment about the victim we should give the victim some consideration is correct, and that the word presumption was not that was an inartful word to use. And that
inartful, and it was just a few words right before you mentioned the presumption of innocence that the defendant gets, which is we all understand is a constitutional principle. So, I mean, it seems to me that this one you've really got to give up on.
I think comparing it to the defendant's presumption of innocence and saying that there is some sort of legal presumption for the victim, that is not a correct statement of law.
Now, let me move you over to the question that I asked your opposing counsel. Am I looking at the right element, that when I look at the force or threat element of the crime convicted of, you don't have anything else other than her word and his word? You don't have any physical evidence. I can't see anything, so I'm asking you what else you might have.
And, Your Honor, let me make sure I'm understanding. It's just her story about how she was forced into the house, led by her arm.
You've got an element that you have to prove beyond a reasonable doubt of that the confining was by force or threat. And I could give you I don't have my glasses on, but it's force or threat. I just don't see any other evidence for that element that you're required to prove beyond a reasonable doubt in order to convict the defendant. I don't see any other evidence besides believing the victim or believing the defendant.
I think that's correct. And just believing, if I can go to say that the victim the corroboration of her telling other people. So that's still the same evidence, but just being told consistently over time the same coherent story. But I do think that's enough. That's strong evidence here, and the jury could absolutely convict based on her word alone. If I can move to the harmlessness for that only error that the Court of Appeals found, under Sherman, we do look at the impact on the jury. We look at whether it was prejudicial or not. And this case was done under the old standard. So there are just a couple of things I would like to point out to support the state's position that this was harmless beyond a reasonable doubt or not prejudicial under Sherman. The Court of Appeals noted some of these things, that the comment was vague as to what consideration she should be given, but then we've already kind of hit on that presumption is not the same as the presumption of innocence. If we look, this comes, I believe, in rebuttal argument, and if we look at the initial closing argument and the argument as a whole, this argument was really based on the evidence, and I believe the prosecutor did an appropriate job in telling the jury what they can look at when they're determining credibility. And they looked at the evidence, and he really focused on what the victim had said and gave them reasons to believe what she said and to find her credible. So I believe that the overarching theme of the argument was to look at the evidence and to find out and to use these factors that he was telling the jury about to find her credible, which is appropriate. Her account of the events was consistent and coherent. And again, he went through the testimony of the officer, the detective, Joy Thomas, all of those people where there was a consistent...
All those statements may be and probably are proper statements. But, yeah, it's this sort of the flip side of the question I asked opposing counsel. How do proper statements somehow mitigate an error that, frankly, on the face of it, appears to be pretty prejudicial? How do you unring that bell? You tell that the prosecutor effectively tells the jury, look, you've got two sides and they stand on equal grounds in front of you, and you're like the tiebreaker, basically. And that's just a misstatement of the law. And it, again, how do you unring that bell? That's what I'm struggling with, no matter how many other proper statements you make.
Well, I think you have to determine whether the jury focused on that one statement and found that to be prejudicial. And I think that if there are other appropriate statements, this court can...
Well, you have to convince this court,
right,
beyond a reasonable
right,
doubt, that there's no reasonable probability that it impacted the outcome. That's a higher burden than us just trying to throw a dart and decide whether they considered it.
Correct. And my position, the state's position, would be that one error out of a very appropriate closing argument where the prosecutor made, all the other statements that the prosecutor made were found to not be error. I think the court can weigh that, and I think that my position is it does mitigate one error as opposed to several.
Let's
Yes,
put it
sir.
in procedural context. This was the second trial. First trial was a hung jury. The jury couldn't decide.
Yes.
The second trial, the jury rejected a bunch of the charges that were filed and settled on a lesser crime. And in that, the errors in the second trial were not present in the first trial, were they? The statements.
I don't remember. I mean,
Well,
for the purpose of argument, no.
You see where I'm getting at. You have a hung jury, and then you retry it, and you have prosecutorial error, and you get a little bit. You don't get the whole thing, but you get a little bit. You get a lesser included. And in that context, I'm loath to say, well, there was no impact. There was no impact. There was no possibility there was an impact on the jury, when in fact, what happened would intuitively indicate that there was an impact. You understand what I'm saying?
I think so.
And you
Your Honor.
didn't get just any lesser included. You got the lesser included that hinges on credibility, which is the error. The statement about her credibility. So, I mean, I think that adds to what my colleague has just said. The difference in outcome was on the crime that hinged entirely, where all the evidence was he said, she said. We've established that, right? It was strictly he said, she said on whether there was force or threat. Only
Yes.
her testimony and her repeating of that testimony to the various people, that's all you have, right?
Sure, but I think we have that for the rape too, as well as the criminal sodomy. I don't know. I mean, we have corroborating evidence in that she told the detective, and the detective went to the house and found those items and things like that. But I guess I don't find it to be that much more or less evidence to the kidnapping as I do to the other crimes.
So in other words, there's no more overwhelming evidence on those crimes that were rejected than the crime on which he was convicted.
Other than the corroboration of her story to other people.
Right,
Yes.
Same thing. It's the same thing. There's a story that gets repeated to several people.
And the other people are the investigating officer, right? trying to look at the testimony I'm trying to look at the interview by the sexual assault nurse, and I don't see references to kind of what happened. There may be there. We'll just have to go back and look at the transcript. But I'm asking you, I guess, in your memory, do you know whether the nurse testified to the jury about the story that the victim told regarding force and threat, that element?
Your Honor, I thought she did. Well, I can remember Joy Thomas talking about the phone calls that were made in the house. So I believe that the victim did talk about what happened in the house. She gave her the story that she was supposed to go to work. I think I cited on page 8 of my brief but without knowing what record exactly volume 8 is. I don't know if that's Thomas or Miss Craig, but I think she did tell Miss Thomas.
Well, we can double check that, and then I don't have anything in my notes about anyone else that she would have told the story to in a consistent way that you would consider corroboration. So we're narrowing our field of corroboration to the officer and potentially the nurse, right? No one else?
Yeah, I think maybe there was an initial officer, a detective, and Joy Thomas. I don't know if there was any, I tried to go back and find this testimony. She said that she called the YWCA or the YMCA, and I don't know
But that
if
was
anybody...
about not making her appointment.
Well, I think that maybe would have prompted her to call law enforcement, and then we get to all of the law enforcement that she told. But to get back to your Honor's question about the first trial, I guess it's our position that I understand your point in there was no misconduct in that and then this statement is said and it changes. But I just don't believe that we can compare those two. I think you have to take it without thinking about anything that happened in the first trial. So, I mean, I don't think that that's something that you can compare. I think this has to be on its own, on its face.
Why not?
For this jury.
Why not?
Well, that jury didn't. I guess I don't understand how you can compare what that jury didn't hear. This jury didn't hear that.
Right.
So you don't know how this jury would have.
Actually, this jury did hear it. The last jury didn't.
Right. And I don't think that we can at this point.
I understand you don't think so, but why not besides that? Do you have anything that tells us that? I mean,
You're asking us to size it up. I mean, that was your original argument. That was what prompted the questions from my two colleagues to my left. You just said size it up. It doesn't look like it should have affected them. And if we're supposed to size it up, if that's the standard, why do we not consider the fact that you got a hung jury the first time around where this didn't happen?
Are you getting to in Sherman, why can't you consider this for reversibility?
Yeah, why? That's what I'm getting at.
Okay. Sorry, maybe I didn't understand that
Okay,
before.
sorry if I was unclear.
No.
Okay.
I would think that I guess my best argument would just be to take it on its face for this jury.
But somehow
they were given the
limit
same
ourselves to the
instructions.
second trial. That's all I'm getting at. I mean, you don't have any support for that in any case law or anything that we should limit ourselves to that
Not
second
at this
trial.
point, no.
Okay, all right, thanks.
Wasn't the evidence different in the second trial? At least some of the evidence was different in that the first trial just relied on the victim's statement that she was present at the house and the events occurred, and then at the second trial there was bolstering of that evidence through her sister and some other police evidence that indicated that she was actually present at her mother-in-law, or at the residence that morning.
I believe that's correct, Joe.
So-
But even if it is, that doesn't go to credibility about
Right.
what occurred while at the house or why she was there or why she stayed.
Puts
I
her in
mean,
the house.
that one element that
Right, puts her at the
Justice Biles had focused upon, the force or threat. It's just presence.
Puts her in the house, yes.
Yeah, and that wasn't contested really.
No.
Yeah, the presence.
yeah. Okay, thanks.
And do you agree that Sherman sort of leads us that way? That we're no longer worried so much about the prosecutor's intent, whether it's ill will, bad faith, that kind of thing. And so we're talking about the impact on the jury, which lessens the mitigation of all these non-erroneous statements, because that would just go to the fact that there was ill will or bad faith and not to the impact. And so when we're focused on the impact, I don't see why we can't look at what actually happened here. You understand? When we're focused on the impact on the jury, then we look at the outcomes.
Between the first and the second trial?
And between the charged and verdicts, charged crimes and verdicts.
Yes, I mean, I think that the court in Sherman was trying to get away from using the prosecutor's intent and the three-prong, reversibility factors, yes. I think that I'm having trouble narrowing down what your prejudice, that test should be in this moment, but I think that the fact that, I would use the fact that the jury acquitted on several crimes to support the state's argument that it didn't impact, this particular statement didn't impact the jury. Because if they believed what the prosecutor said, and there is a legal presumption that you should believe the defendant, that the defendant has this presumption of credibility, then I think that the impact would be the jury accepted that and would convict.
Doesn't
all
that
of the
cut
crimes.
both ways? In other words, the state did make the argument, it's kind of all or nothing. That was the state's argument. Either she's lying or she's telling the truth. And I'm paraphrasing, they didn't say it exactly that way. But that was essentially how the case was presented to the jury. And the jury clearly did not believe the victim with regard to the greater crimes. However, then we have the state's erroneous statement to, the victim, quote, deserves a certain presumption. And isn't it just as reasonable to think that the jury thought of that erroneous statement and said, well, the victim deserves a certain presumption as well, so we're going to convict on the least severe crime we can, even though we really don't believe the testimony of the victim, as demonstrated by the fact that we acquit on the more serious crimes. I mean, isn't that just as reasonable of an explanation of what happened?
I think respectfully, I would disagree that it would have to be they would convict on all or nothing. So I don't think it would be, it's as reasonable as them choosing to convict on the kidnapping as opposed to acquitting on all of the crimes. I think that was my last factor, and just really harping on the fact that they acquitted on some crimes and convicted on the other. Other than the fact that the comment was brief one time, and then just to point to also the jury was instructed that statements of counsel are not evidence, and that the prosecutor here did hit on many of the jury instructions, really focusing in the jury on the elements of each of the crimes and trying to focus them in on this is what they had to find to convict on each of the crimes, the rape, the sodomy, and the kidnapping. I'm out of time, so I would just respectfully request that this court find that the error in this case that the Court of Appeals found was harmless.
Counsel, do you know offhand how many different times and in how many different ways the jury was instructed about the presumption of innocence of the defendant and the prosecution's burden of proof and what that proof would be?
I know they were given a jury instruction on it. Do you mean during closing argument? I mean, I think it was...
The jury instructions, how many different times and how many different ways was the jury told that the defendant basically can sit here and do nothing, it's the state's burden and this is what the standard is, and he, in this case, is presumed innocent until proven guilty beyond a reasonable doubt? I'm assuming all that was presented at the jury instructions?
Yes,
And
Your Honor.
a number of times?
I don't know if it was just one instruction on the general burden of proof or if there were two. I can't recall at this time, but I know there was an instruction on the burden of proof and that being on the state. And I know that the prosecutor hit on that as well at the beginning of his closing argument, and the defendant's counsel hit on that multiple times during her closing argument. So I feel like that was emphasized for the jury, the burden of proof.
I'm just kind of curious how many different times the jury was told about that, and then the prosecutor says, and oh, by the way, the victim deserves a certain presumption, i.e. on credibility, and I'm just curious whether it's possible the jury said, well, we've heard all this jury instruction and argument about presumptions, and so I guess we're going to have to conclude that the victim is credible unless she's proven incredible beyond a reasonable doubt. Any chance of that happening here?
There wasn't an instruction on victim credibility, so I would say that if they were looking at the instructions themselves, they wouldn't have that to turn to. They would have the instruction that statements of counsel are not evidence, and I guess that's all I can say on that one, Your Honor.
All right, thank you. Any further questions? Thank you.
Thank you.
Your Honors, I'm prepared to waive rebuttal and simply request reversal of Mr. McBride's conviction.
I have one question. That one facet of the Court of Appeals analysis that I don't think has been specifically addressed today, and I'd like to hear your response to what they said, was that there was no other explanation for Craig's presence with McBride at the house other than, as Craig testified, she was forced into the residence. Do you have any response to their reasoning on that point?
I think that's correct. The defense did not present witnesses or testimony. Mr. McBride did not testify. I think the inference was that defense counsel tried to communicate was that she must have gone voluntarily, and they were having an argument about the money that was in her backpack and that she said was in this other house. But I do think that that's correct. There wasn't evidence presented for an alternative explanation about how she ended up at
No
the house.
direct
So-
evidence. No direct evidence.
That's correct. Your Honor.
So it would be
They've been together.
circumstantial evidence about the backpack and the money, and the fight being over the money would be the other factor you would focus on.
Yes.
Anything else? The defense counsel during her closing argument, she argued a lot about the presence of the hickey on the neck and how the nurse did not detect that. And I think her argument was that that is the catalyst event in this whole series of events, and that's not corroborated by physical evidence. So therefore, the testimony that follows must not be true. That's not direct evidence. That's sort of an inference that defense counsel argued to the jury.
Other than speculating about what happened in the first jury trial as it relates to the jury deliberations, do we know anything about that? The length of deliberations, whether questions are asked, any kind of outcome there? Was it
With the first
deadlock?
trial.
How the deadlock nature of it? Anything like that?
I apologize,
I didn't see
Your Honor.
anything. That's why I hesitate to ask. But is there anything?
I do not know. That might be contained in the record, but I apologize. I do not know the answer to that question.
But they were hung on all counts.
Yes, that's my memory.
Any further questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. This time.